your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Danielle, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome. Welcome to the show. Today is Friday, and this week it's Judge Erane Washington, and the cases are being heard in front of her courtroom. So let's get this started. Share screen. Judge Washington. So let me make this bigger.
December 29th, 2025 at 10 a.m. I'm setting it up for a contempt hearing, so make sure it's paid, okay?
Okay.
All right. Thank you. Bye.
Bye.
All right, the court will recall the Ozell Hyman matters, 25 FB 1036 and 25 FB 1007.
What's for the people?
Allison Muller here on behalf of Ozell Hyman. Ozell, could you have them unmute you again, please, and then state your name?
Hello, I'm Ozell Hyman.
Thank you. All right, Ms. Muller, you wanted to talk to your client.
Yes, Your Honor, and I don't know if the court would be basically willing to give us an idea of what may happen with Ozell's bond before we make a decision on the case. I mean, the fact of the matter is Ozell has just served the time on this case, and so if the court's not inclined to give him, or to reinstate a bond that he could post or a personal bond, then we are going to be setting it for bench trial. But if he is out, his preference would be to have a jury trial, but he's not willing to or doesn't want, his preference is not to sit for another, 6 weeks until the jury trial. And him and I did have a realistic conversation about if the court is going to give him another chance, and he realizes he's had a couple already, if he can realistically, comply with the bond conditions. But Ozell thinks he can. He hasn't had any issues since we had the hearing on his GPS tether, so that shouldn't be an issue. But as far as alcohol, scram, sober link, whatever the court would deem appropriate, he does think that he can comply until whatever his next court date is.
Ms. Woods, I'd like to address the bond issue because, and I'll tell you what my thought processes are. Are we back on the line? We are, yeah. What my thought processes are, and first of all, Mr. Hyman didn't turn himself in, so that cuts against him. But secondly, he didn't run either. He didn't cut off his tether. And he knew that they were coming to pick him up and he waited. So that is a positive for me. And the drinking obviously is a problem. He knows it's a problem. So I'm hopeful that what I'm going to order is that he get into some AANA classes or meetings so that he can begin to at least see his issue a little bit more. So that is what I'm thinking right now. And you can base your argument upon my thought processes if you have one, Ms. Woods.
Judge, my only argument would be is that I believe he also has an issue, which doesn't want to admit to himself or to others. He doesn't appear to be able to follow court's orders based on, these issues that we've had with his tether and testing and things like that. So that's my concern, is that he's still not going to follow court orders.
Thank you. And Mr. Hyman?
Yes, Your Honor.
I'm going to give you another chance, but I'm also going to order that you get into some treatment, and you can begin that process of getting into treatment. But in our time period, I'm going to order that you attend AANA meetings, and I know you're on tethers, so you can attend those online. Okay. I know you know how to work online because you showed up here online, but they have AANA meetings online. Okay.
Okay. I can do it.
I want you to get some help, and you should probably talk to a therapist because you're still in grief, like deep grief. Being in grief sometimes makes it very difficult to not drink. So you probably need to get a therapist going. So it's a lot that I'm asking, but if you don't comply, you're going to find yourself back here in jail. And I never want to force anybody to have a bench trial because they feel like they have to because they're in custody. But I'm not doing this for that reason. I'm doing this because of your own behavior. So it is your behavior and not running and not drinking after that and continue to test is the reason why I'm giving you this second opportunity. So please take that into consideration, Mr. Hyman.
Yes, Your Honor. Thank you. Thank you so much. I'm sorry. I'm a mess. I'm sorry.
You don't have to apologize, sir. You're going through a lot. It's a human experience that you are basically becoming very vulnerable in at this moment, and I'm okay with that. But you've got to get yourself some help, and you've got to get out of denial. So I'm putting you back on Scram, Tether. Wait, no, I think you were on SoberLink Tether. And you were on GPS Tether, correct?
Yeah, yes, Your Honor. Thank you so much for this opportunity. I'm gonna give it my best shot. I'm so grateful. Thank you. Thank you.
Now, there's no reason for the complaining witness to show back up, Ms. Mueller. You do understand that, so this would be a trial.
We understand, and you understand that, right, as well, Mr. Hyman?
Yeah, yes, I do.
Do you want another final settlement conference date, or do you want to go straight to jury selection on November 7th?
Your Honor, since there's no need for the complaining witness to appear, I think if it's okay, we would just set the next date for the jury selection.
November 7th, 2025 at 8:30 a.m. That's in person, Mr. Hyman.
Yes, Your Honor.
Your bond will continue with all those normal conditions, and I'll adjourn this 25 FB 1036 case, which is just fines and costs at this time, I think is what he's supposed to be paying. Yes. So I'll adjourn this one to that same November 7th date at 10 a.m. I'm sorry, 8:30 a.m. So come prepared for trial, dress appropriately, Mr. Hyman.
Yes, yes, Your Honor.
All right, I do also need to put in here the stuff I told you, which is defendant to get an assessment for treatment done. And defendant to attend you need to attend at least 4 AA meetings before then, okay?
Yes, Your Honor. So that's one per week.
Pretty much one per week. Or you can do more than one per week if you so choose. But you need to go to those meetings and start getting acclimated to them. And I can tell you that I've attended to support people and I'm moved and touched by them. It's life-changing if you open your mind to what they're trying to provide for you. So I hope you do.
So I do need the help, and thank you. Thank you.
Good luck, sir.
Yeah, thank you, Your Honor.
See you in November.
See you November.
Mhm.
Thank you, Allison.
Thanks, Ozell. Talk to you soon.
Yeah, okay.
Sir?
Are we having a full restitution hearing on the Fleming matter?
I believe so, Judge, and then we also have a restitution hearing set for Scott Reese, and I don't know if that's going forward or if they were able to, or are we willing to come to an agreement?
Your Honor, did the court receive my memorandum of law this morning?
No. I've been on Docket. I wouldn't have an opportunity to see a memorandum of law.
I understand. I did prepare one as well. I sent a copy to Ms. Woods.
Hold on, please. Can I see counsel on the Fleming matter in a breakout room?
Yes.
No. Ms. Woods, it turns out that Mr. Magoo is in a breakout room with his counsel, so maybe going directly into the room with Ms. Medina would be the more prudent
Okay.
method of trying to get through this. So I'll do that and put the two of you in a breakout room. Yes. And the victim advocate also. All right, the court will call the matter of Ypsilanti Township versus Tyrone Davis, case number 19W008250.
Paul Barnett on behalf of the township.
All right, this matter is before the court on a contempt of hearing proceeding. The defendant is supposed to appear on 3 separate occasions before the magistrate and failed to appear. Defendant was set for contempt before me. Defendant has failed to appear and failed to defendant has failed to appear and failed to pay. Bench warrant to issue. 2,700, 10%. We'll call the matter of Ypsilanti Township versus Abraham DeCasa, 22W000851.
Paul Barnett on behalf of the township.
This matter is set for a contempt hearing before me. The defendant failed to appear on 3 separate occasions in front of the magistrate. Defendant has failed to appear here today and failed to pay. Bench warrant to issue in the amount of $2,500, 10%. We'll call the matter of Ypsilanti Township versus Peter Denmark, case number 13T9775.
Paul Barnett on behalf of the township.
Defendant has failed to appear and failed to pay. He failed to appear on 3 separate occasions in front of the magistrate. Contempt is found. Bench warrant to issue. $3,500, 10%. Yes. I won't call it. I know. As soon as Ms. Woods returns, I'll call the Magoo matter.
Who wants to get Frank? To Frank down, Frank nine, round up the court, we'll have to go.
Wait, let me go in here and see if I can. I'm sorry, what?
If you look, that's fine, if you go back in, let them know that I can't send the town back in, because she won't, then I would have to move them all to a different room.
Well, they're not. Can you respond? No, Ms. Woods needs to come back out. Please. Can you do that or no?
I can try to force it.
Okay.
There we go.
All right, the court will call the case of the state of Michigan versus Daniel Magoo, case number 25S00289.
Tiffany Woods for the people.
Allison Muller here on behalf of Daniel Magoo. Mr. Magoo, can you please state your name?
Good afternoon, Daniel Magoo.
Good afternoon, Mr. Magoo. All right. We're here for an adjourned pretrial in this case.
Yes, Your Honor. After talking with Mr. Magoo, I do have a request of the court, and we had conversations with Mr. Magoo about this, but basically what's happening, I understand there was an attorney breakdown with his felony attorney from my office and him on his felony matter, so he's just recently been reassigned to Mr. Drukas. Mr. Magoo today is requesting that my office withdraw from this case, also given the same reasons, and what he thinks might be our inability to work together, and also his preference that Mr. Drukas handle all of his matters. I let him know it doesn't necessarily work like that, and unless he's, stating there's an attorney-client breakdown, then the court might not grant that. But I did want the court to know that that is his request.
Is there an attorney-client relationship breakdown or no?
Your Honor, we've only been adjourning at this point because we thought that the global resolution might be possible. I still think that's possible. I think I'm able to represent him and obtain a global if it is possible. And if at one point we learn that it's not, then I'll certainly transition into trying to resolve this matter. So from my stance, there's not an attorney-client breakdown. And I did indicate that, well, Mr. Work spoke with Mr. Magoo and indicated that. But I understand it's still Mr. Magoo's request for our office to be taken off. And so he asked that I address it to the court. And again, we've explained to him that it probably will not be granted unless he's claiming attorney-client breakdown, which I'm not sure if he is or is not.
Ms. Woods?
Judge, I'm trying to look through my notes. I don't see that anyone's requested a global offer. I'm more than happy to see if that's something we can do. I know this has been being adjourned based on his other felony cases. We did place a plea offer on the record. That was back in July. And then it's just been being adjourned to see what happens with this felony case. No one's ever come for a global or requested us to work out anything other than waiting to see what happens to the felony. Like, I guess they assumed it was going to be dismissed or not go to preliminary exam. I'm not sure.
Ms. Woods, I'm sorry if you weren't included in any emails. His attorney with my office, Alex Warren Green, was, I believe, coordinating with the prosecutor at the felony stage. And if there was a global, I hopefully would have included this, but I'll certainly reach out to you directly about the global.
I know that an argument was made on his behalf back in September 15th, along with everything that the prosecutor just said, for a bond reduction, which I granted at the request of his counsel at that time. And as you have indicated, Ms. Muller, defendant indigent is not able to determine who their attorney is going to be. That is assigned based on the assignment office. And at this point in time, if you're saying there's not a breakdown, I'm not understanding. He doesn't get to just say that this attorney, he wants to have the same attorney. That's not how that works, Mr. Magoo. Is there something you wanted to say, sir?
It was in reference to the global resolution that I apparently the prosecuting attorney, Ms. Woods, has not received anything on. I just thought it would be, I thought having Alex and also Ms. Moeller representing me in both of my cases would have some kind of cohesive approach, but being that there was a breakdown in my felony case with the public defender's office, I just wanted to really simplify things and reduce the confusion with, obviously there's a confusion with who's messaging who on the global resolution. So I just thought it would be simpler and better for me.
Thank you. I can appreciate you thinking that, but that's not how it works, unfortunately, sir. So what I'm going to do at this time is I'm going to continue counsel as counsel is. Ms. Mueller, when we come back the next time, you should have had communications with everybody as to what's going on with the global resolution, including his new attorney. Is that Mr. Drukas?
It is, Your Honor, and that's set for this week, I believe tomorrow.
Hmm. I'll put this over to October 16th. That's Thursday, right?
Yeah, sure.
October 16th, 2025 at 9:00 a.m. And hopefully we have a global resolution by then. The bond will be continued, as I said it last time. He has a 1,010% on this. I'm not sure what's going on the other matter, but he has a GPS tether if he's released on this case, which he can be.
Thank you very much, Your Honor.
You're welcome. And then on this one, I need more than 20 stickers. One for the chance. All right. We will wait for the next inmate to be brought, and in the meantime, I'll put you back in the room with Miss Allen and Miss Williams to see if we can see where we are on the other matter.
Thank you, Judge.
What will be in a brief recess while they talk in the other room. What is that? What is his name? Is someone from the PD's office handling the entirety of Mr. Antoine Brown's case?
Yes, I'm appearing for Mr. Brown.
You're handling them all, even the one with Miss Foster Tucker on it?
No, I am here on 0491 and 1241. Can you give me that case number?
Case number 24FB1048.
Okay.
He's here for a sentencing on a violation of probation.
Yes, and I believe that is actually the case I spoke with her about in the one ending in 1048. I think she said she can't represent him because that one is the probation violation. Okay, so yes, I can appear on all.
And have you talked to him about them all?
Yes, I appeared for the last couple.
Well, he was arraigned on a new violation. Is what?
The violation for contacting the complaining witness.
Yep, on September 22nd, he was arraigned by, okay, so that was here in court.
Yes.
Okay. And so you don't need to talk to him right now.
No, I don't. Thank you.
Thank you. All right, we're still in recess. I'll be back. Hopefully they'll only be in the breakout room for a minute, Ms. Woods. I can't handle these matters without Ms. Woods. Is there anything quick that we have to do, or is this going to be an argument?
It will most likely be an argument, Judge.
All right, thank you. All right, the court will call the cases of Antoine Brown, case numbers 24FB 1048, 25FB 1241, 022S 00491, and 22S 004.
Tiffany Woods for the people.
Ashley Moten on behalf of Mr. Brown. State your name, sir.
Antoine Brown.
Perez Reyes.
All right, we're here in these matters for 2 sentencings and 2 show causes.
Yes. Oh, I'm sorry. Did you say something?
No, I didn't.
Oh, okay. So backtracking, Mr. Brown pled guilty in front of Judge Pope of the violation of contacting the complaining witness while he was in custody. We provided the explanation that Mr. Brown was trying to arrange so he could get his children when he got out of custody. He takes responsibility for that violation. He did not contact the complaining witness while he was out of custody. Instead, while he was out, his sister and mother, they were arranging so he could get the children. He is a father of 9. When he got out, he got all of his children together with his family. He was only out for 8 days before he was picked up on the violation. Also, while he was out, he found employment. He enrolled with CMH. I believe at this point, he probably completed his intake. He also enrolled in Accountable Choices. He missed his orientation for the job because he was in custody. So, Your Honor, at this point, he's been in custody for 26 days. His first grandchild was born since he's been in custody. He is an active father. Again, he takes full responsibility for the violation. I'm just hoping that at this point, after doing 26 days, that is sufficient and he is able to be released. He is very adamant about getting on track with everything, completing his probation conditions and complying with the court's orders. If there are any additional conditions, we understand, but we are asking for a personal bond.
Thank you, Ms. Woods.
Yes, sir. So he did admit to making those phone calls to the victim while he was in custody. he has a real issue with, following the orders of the court. And I would leave it up to, the court's discretion how you want to handle it, Judge. Thank you.
Thank you.
Speak, if possible.
Yes, sir, you can speak.
Since I've been incarcerated, I seen Jim, the accountable choice teacher. I am in the class. He gave me the book also. I have the book with me here today. I made a payment, $50 payment towards my probation already. I apologize to the court for making those phone calls. I was caught up in my emotions, I would say, more than anything. But I'm just trying to get back out to my house confinement and just continue to do what I have to do to get through this.
Did you have your mental health assessment done?
What I did is it was supposed to be that Friday. I came to jail Thursday and I was supposed to do it on Friday.
Mm-hmm.
So I set it up. I made the phone calls and everything that I needed to take care of. I took care of everything that I was doing when I was outside. I didn't violate or anything.
So at the time of sentencing on the 25 FB 1241 case, I put you on probation for 18 months
Yes.
and gave you 365 days with credit for 36, with the balance of that time to be suspended.
Yes, ma'am.
And you've been in an additional 26 days after that. Is that correct?
Yes, ma'am.
All right. 26 days in the Washington County Jail. Credit for the 26 served. Your probation is reinstated in both cases. Sir, please don't violate again, or you won't be looking at a simple 26 days in jail. Okay?
Yes, ma'am. So that's back to house confinement, right?
It is back to house confinement,
Okay.
and I will see you back
On the-
here 60
20
days
On the 20th. I think I have a review with you on the 20th, October 20th.
on October 20th.
Yes, ma'am. If I'm not mistaken.
That's where it had been originally set.
Okay.
Adjourn it out a little bit because that's only 3 weeks from now.
Okay.
I'm gonna see you back here on November 10th. You should be in your programming and have everything done by then.
Yes, ma'am.
Your order to show cause will be on that same date too. November 10th, 2025 at 10:00 a.m. Okay,
Okay. Thank you.
you're welcome.
Is that all?
That is all, sir. You're reinstated with probation on your original terms.
Okay. Thank you.
Mhm. 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 Johnny Reyes, Perez Reyes.
We apologize, names that we included on the in custody docket, but I was here this morning.
Does he have does he need to see somebody?
He does, he needs to go into a breakout room with this and sewer, but there's also an interpreter required.
Oh, okay. So let's call the interpreter. All right. Good morning, Charlie. Please raise your right hand.
Good morning.
Do you swear or affirm you will translate from English to Spanish and Spanish to English to the best of your ability?
I do.
Thank you. We are going to now place you into a breakout room with Mr. It's Miss Moulton.
Yes, I can do it.
All right. Perez Reyes and Miss Moulton will go into a breakout room
Certainly, thank you.
with you. I'll pass that case. All right, while they're in the breakout room, I think I can try to do what we can in the Fleming matter. The court will call case of the state of Michigan. What?
Good afternoon, Your Honor.
Hold on a second. I'm sorry, we can't do anything on that case until Mr. Fleming is brought from the jail.
I understand.
Can I see counsel in the breakout room while we wait for him to be brought? While we get through some other cases so he can be brought. Chisala DeLeon, case number 21S3928,000.
Tiffany Woods for the people.
This matters on the docket today for contempt of court. The defendant failed to appear on 3 separate occasions in front of the magistrate, and the defendant has failed to appear today. The court will issue a bench warrant. Defendant also has failed to appear and pay. Is that correct? Bench warrant to issue in the amount of $2,300. Contempt is found. The court will call the matter of the state of Michigan versus Kenneth Dennis, 21S38495158.
Tiffany works with people.
Defendant's supposed to be here for contempt of court. He failed to appear on 3 separate occasions from the magistrate, and also defendant has failed to
Okay, correct.
pay. Contempt is found. Bench warrant to issue in the amount of $2,200, 10%. What will call the case of the state of Michigan versus Shannon Brown, 19S00424.
Tiffany works for the people.
Defendant made a payment of $30 in this particular matter. It's on the court's docket for a payment plan review. Defendant's not quite on track, but there's only a balance of $94 left. The court will set this for December 1st, 2025 at 10:00 a.m. Hopefully it'll be paid by then. Is is Ronnie McBray not in custody either? The court will call the matters of Ronnie McBray, case numbers 19FB1608 and 21S00313.
Tiffany works for the people.
Allison Muller here on behalf of Ronnie McBray.
Mr. McBray was supposed to be brought. Was he read it out?
Yes, Judge, I believe we did a writ. This happened last time too.
It did.
Yeah.
I think so.
MDOC never responded, apparently. We'll try it again. Let's try for November 3rd
What time, Judge?
at 10:00 a.m. for sentencing.
November 3rd, 10 a.m. All right.
Bond continued. November 3rd.
November 3rd, thank you.
The court will call the case of Francisco Trujillo, case number 23S00512.
Tiffany works for the people.
This is actually Mr. Shimke's matter. Is it? Oh. Oh, because it's a yeah.
I apologize, Your Honors. This does look like a PD's matter.
Yes, it is, Mr. Trujillo.
Okay, Allison Muller here on behalf of Mr. Trujillo. It looks like, Your Honor, we did have a breakout room request. We weren't able to make contact With Mr. Trujillo, we did leave a voicemail.
He has a bench warrant on his other case, so apparently he's just in abscond status, so bench warrant to issue, no bond. Who's in the room with the translator?
Mr. Perez
No, I meant
and
Richard.
Ms. Moulton.
Reyes Gamboa?
Yeah, they need to, you said what now?
Perez Reyes, Mrs. Reyes and.
Yeah.
We already handled that.
Right. Perez Reyes is in the breakout room, but they need to,
That's it.
okay. We can't do anything else until they come out, because can you see if the jail can perchance set us up with 2 rooms?
Okay, I'll send a message asking if they're able to.
Okay. Okay, here we go. He doesn't need to go in a breakout room, does he?
I gave her the key to the.
Right. The court will call the case of the state of Michigan versus Robert Hayes, case number 23 FB 1489.
Tiffany Woods for the people.
Allison Muller here on behalf of Robert Hayes. Robert, can you go ahead and ask them to unmute you and then state your name?
It's Robert Lee Hayes Jr.
All right, we're here today for a review. Mr. Hayes is apparently still stopped because of due to the warrant out of Wayne County. Is that true?
That's correct, Your Honor. That's my understanding. I think he had an original date on that Wayne County hold and then it was missed. And he's been sending requests since then, but I don't think he has a court date on his hold. So I don't think he's able to be released to treatment until those are taken care of. And so, Your Honor, at this point, I believe it's still Mr. Hayes's request, given that he has been held and has served a significant amount of time, to ask the court to just sentence him to the time served sentence at this time.
How much time does he have?
Hold on, I'm sorry, Your Honor. I've been having troubles all morning with XGL. I'm gonna see if someone can look that up for me.
He had only had 7 days served at the time of August 18th. So
Yeah, 48 days now.
he wants the 93-day jail sentence.
Mr. Hayes, is that still what you want, knowing how much credit that you have? You indicated you didn't want to do probation when you were released. Is that still the case, or have you changed your mind?
No, it's still the no probation and time served.
I'm not doing time served. I'm doing 93 days in the Washtenaw County Jail, giving him credit for the time he has served, but it won't be a time served sentence and he's done.
I'm sorry, I misstated that, Your Honor. Mr. Hayes, you understand you have additional time to serve, correct?
Right, yeah. Because I'm at 40. Well, I've been here since the 18th. Well, the 13th. I don't know if that's how it would go, but since the 13th, I do know it was 48 days as of now that I've been here. So I don't know exactly how it goes. If it will be the 18th, starting the 18th and then up, or from the 13th, I don't know.
Mr. Pappenhagen, what have you calculated as his credit, please?
It'd be 47 days, Your Honor.
47 days credit is what he would get. Thank you. Ms.
Thank you.
Woods, anything from you?
Judge, I would just ask that he, it gets, serves the full.
Ms. Woods, you need to stop.
Testing. We're back on the record, Your Honor. I apologize.
All right, now you may proceed, Ms. Woods.
Judge, if he doesn't want to do probation, I just ask the court to, make him serve the full 93 days, with the 47 days credit instead of time served as we're requesting.
Thank you. Mr. Hayes, anything you want to say additionally, sir?
I don't know exactly quite what she means as far as that goes, but while in here, I enrolled into classes. I don't know if you could see it or not, but I have enrolled myself into the Don Farm class. I'm waiting to hear back as far as the AA treatment goes, the class for that. So, I mean, I do have that going as well as while I'm in here.
Sure. So your request to revoke your probation is granted. It is the sentence of this court that you serve 93 days in the Washtenaw County Jail. Credit for 47 served. Defendant to serve the balance. Fines and costs waived. We're all set, sir.
Thank you, Ms. Washington.
You're welcome, sir.
You have a great day.
Thank you, you too. All right, the court will recall the matter of the state of Michigan versus Joni Perez Reyes, 25 FB 1235.
Ashley Moten on behalf. Oh, I'm sorry.
First Reyes, el llamado del caso del señor de Michigan en contra del señor Johnny Pérez Reyes, 25 FBB F35.
Ashley Moten on behalf of Mr. Perez Reyes. Please state your name, sir.
Pérez Reyes, tenemos a la señorita abogada Ashley Morton. Señor Reyes, por favor, diga su nombre.
Johnny Javier Pérez Reyes.
Johnny Javier Pérez Reyes.
Thank you.
Gracias.
We're here for the first pretrial in this case.
Nos encontramos aquí el día de hoy para este caso como audiencia, preliminar o previa juicio.
Yes, Judge. We did not have a phone number for Mr. Perez Reyes. So Mr. Mercer has not been able to address the pretrial. We would like to request an adjournment and an opportunity to address bond.
Responde la señorita abogada del señor Reyes que todavía no contamos con el número telefónico del señor Reyes, entonces por lo tanto no ha sido posible hacer ninguna adaptación o ajuste por parte del abogado señor Mansur a esto, en su caso, razón por la cual para lo que es la audiencia preliminar nos vemos en la necesidad forzosa, por lo tanto, de solicitar ante este juzgado el aplazamiento de este caso para la fianza.
You may proceed with your address of bond.
¿Puede usted continuar con su propuesta para fianza?
On September 2nd, there was a preliminary exam was held where the felony count was dismissed and the case proceeded on the misdemeanor.
Con fecha del 2 de septiembre se llevó a cabo una audiencia preliminar o examen en donde se desestimó o anuló el delito mayor en contra del imputado y sin embargo se procedió a validar el delito menor en su contra.
He was given a $2,000 personal bond plus a GPS tether.
Se le otorgó entonces una fianza de tipo personal por la suma de $2,000, además de un localizador satelital.
When it was time for him to be released, the jail told him that he had an outstanding balance with the tether company of $1,002.
Cuando llegó el tiempo de ponerlo bajo libertad, las instalaciones de la cárcel le informaron que él contaba con un adeudo o un saldo pendiente de un pago de un localizador satelital anteriormente con la compañía proveedora de dichos instrumentos por la suma de $1,002.
He paid the balance and he provided the address of where he will be living, but it is unclear to us why he's still in custody.
Él, de hecho, liquidó ese saldo deudor y también nos ha brindado ya el domicilio en donde él pretende radicar. Lo que aún permanece ambiguo o no claro para nosotras es el motivo por el cual él todavía sigue detenido.
It is possible that he has an ice hole.
Posiblemente lo que tenga el señor Reyes sea una orden de arresto o detención por parte de las autoridades migratorias o ICE.
Can you check into that?
Hay que revisar eso.
I didn't see that, but I'm trying to pull it back up in X-Jail. If you give me one moment, please.
All right, thank you.
Sí lo revisé, responde la señorita Morton, pero así pido un momento para poder hacer revisión de esto.
I'm not seeing that on our end.
De nuestra parte, responde la abogada del señor Reyes que no ve ninguna detención de esa índole.
Yeah, I don't see anything else that would be holding him.
Responde la señorita jueza que no veo nada realmente aquí que lo esté haciendo que permanezca detenido.
I will indicate that bond is continued with the release with Soberlink.
I want to say, yeah, check.
My apologies, Your Honor. Can you repeat that about the bond and the release?
The bond will be continued with him being released on a sober link. And you said home confinement?
Thank you, Your Honor. Bueno, responde la señorita jueza que por lo tanto se va a permitir que se lleve a cabo se ejecute la fianza con la puesta en libertad del señor Reyes, siempre y cuando porte el localizador satelital de sobriedad. La pregunta es, ¿va a estar bajo arresto domiciliario?
I believe it's just a GPS tether. I tried to verify in my court, but it doesn't say tether at all there. So I'm not 100% sure, but usually in our office, we would have specified if it was home confinement.
Bueno, yo creo que es nada más, responde la abogada del señor Reyes, que nada más se trata del localizador satelital. De hecho, creo que nosotros podríamos especificar eso, nuestro bufete jurídico de abogados. No estoy 100% segura de que vaya a ser nada más el aparato o si va a ser arresto domiciliario, pero creo que nosotros tendríamos la facultad de saberlo.
And Judge, we show that it was a GPS tether with a hot zone to the victim's address.
Responde otra persona más que a la señorita jueza, que sí tenemos registrado que se trata de localizador satelital para el domicilio del imputado.
As well as a no contact and no go to.
The interpreter missed that. I'm sorry. Do you mind repeating that, counsel?
We got him, the defendant. All right, I will, continue the bond with the conditions that there's the exclusion zone of 1 mile within the Munger Road address.
Within a mile away from whom, I'm sorry, Your Honor?
From the Munger Road address.
Thank you very much for that. Bien, entonces la señorita jueza responde lo siguiente. Voy a permitir entonces que se ejecute la fianza, claro, estipulando las condiciones de exclusión donde se incluye permanecer con una lejanía o distancia de 1 milla de distancia o alejamiento de la dirección de Munger Road.
For you to have no contact.
Usted no deberá tener ningún contacto.
Let's see. One moment. With Arlette Valley.
No deberá tener ningún contacto en absoluto con la señorita que lleva por nombre Arlette Valle.
No go to her place of employment.
Tampoco podrá presentarse en el lugar de trabajo de ella.
No assault or threatening behavior.
Ninguna conducta tampoco amenazante.
No drugs and no alcohol.
Nada de drogas ni tampoco de alcohol.
Do you understand, sir?
¿Entiende esto, señor?
If so, nod your head up and down, yes.
¿Puede usted mover su cabeza de arriba hacia abajo para decir que sí?
All right, he did. He and the record should reflect he nodded his head. He's muted because of how loud it is in the gym.
Debido a que hay mucho ruido. I'm sorry, Your Honor. Go ahead.
No, you.
My apologies. Vamos a hacer constar ante el acto o grabación entonces que el señor Pérez Reyes acaba de asentir, o es decir, convenir en lo que le acabo de decir, que sí ha entendido las instrucciones o con condiciones de su puesta en libertad, moviendo su cabeza de manera positiva debido a que su micrófono está silenciado por el ruido que hay en la cárcel donde está.
Anything further from anyone else on this matter?
Pregunta a la señorita jueza si existe algo más que alguien desea abordar sobre este asunto.
Not for me, thank you.
Responde la señorita Morton que no, que gracias.
Hearing nothing further, you are excused, Charlie. Thank you. Have a good day, Mr. Perez Reyes.
Señor Pérez Reyes, no hay nada más que tratar. Que tenga buen día. Gracias. Hasta
One
luego.
moment, Charlie.
Yes.
I didn't hear you say the date on the record, and there's also not long listed in.
Oh, that's correct. I guess I need to give you a new court date. October 20th work?
Pregúntale a la señorita jueza si como una fecha nueva de comparecencia ante el tribunal sería el 20 de octubre.
Works for us.
Responde la señorita defensora pública Morton que sí está bien esa fecha.
You are requested an adjournment, correct?
Solicitó, pregunta a la jueza, a la abogada defensora pública que ella pidió el aplazamiento del caso.
Yes, that is correct.
Y ella responde que sí, ella lo solicitó.
October 20th, 2025 at 9 a.m.
Queda como la fecha como el día 20 de octubre de 2025 a las 9 a.m.
for pretrial.
para una audiencia previa a juicio.
All right, now, Charlie, you're all set. Thank you.
Always a pleasure, Your Honor. How about I say thank you?
Thank you.
Thank you.
All right, now the court will call the case of the State of Michigan versus Christopher Fleming, case number 25S00001.
Tiffany Woods for the people.
Good afternoon. I'm Roger K. Green, P33837, on behalf of the defendant who appears by Zoom. Good afternoon, Your Honor.
Good afternoon. Mr. Fleming, can you have them unmute you and state your name?
Christopher Fleming.
Thank you. All right. Today is the day and time scheduled for a restitution hearing in this particular matter. The court did receive this morning a memorandum from the defendant's attorney entitled Defendant's Memorandum of Law regarding plaintiff's claim for restitution. Mr. Green, you may proceed with your argument and your motion today.
Yes, this is my motion to dismiss of the restitution request. Your Honor, there was a release of all claims that was signed by the widow of the decedent on February 25th of 2025, releasing all claims as relates to all heirs and successors and the like. So on that basis, we are indicating to the court that it's my understanding that both of the ladies who are requesting restitution are heirs, and so they are legally barred from pursuing their claim.
Thank you. So that I'm clear, you're arguing that the personal representative of the estate, being the wife,
Yes,
was designated, and you provided as an exhibit a copy of the letters of authority to act as personal representative. That's exhibit A. Exhibit B is the release of claims that you provided, and then you have an order from the court as exhibit C. And what does the order say that would affect this action today, Mr. Green?
Your Honor, the order indicates on the last paragraph of Judge Erane, it says it is further ordered that all other wrongful death claimants were served notice of the hearing by the court, and whether they appeared or not at the hearing, their claim to wrongful death proceeds has been waived. So it seems as if there was an opportunity to file a claim against the probate estate, which was not done. There was also an opportunity to appear in court and seek restitution or to address their claim, and that also was not done. So, and because of the release of claw claims by the personal representative, I'm arguing to this court that the claims of both of these ladies should be legally barred.
All right, Ms. Woods, what is your response, please?
So Judge, you know, they can get restitution either from the civil side or the criminal side. We know that there was a release of claims that was signed by the wife of the victim in this case, and we know that the two heirs here today are Paris and Medina, who are the daughters of the victim in this case. You know, they never received, they actually have, you know, some documented expenses that they paid. They never received any payment from the, you know, the estate when that was settled. They never received anything through probate. They never requested anything through probate. So believing that they could get this money owed to them through restitution. They have a right to restitution. They do have documented expenses that they paid that had to deal with the victim's funeral expenses in this case. So the only way they are going to be able to get paid from this, Judge, is through the restitution process through the criminal court. We are here today asking the court to look at the restitution documents and make a ruling on that, Judge. Thank you.
You didn't address the legal argument that he's making, which is that there's a release of claims from the representative in this case that says on page 1, and she represented the entire state, that says that they acknowledge and release all heirs, executors, administrators, successors, and assigns, and forever discharge Leroy Fleming, Linda Fleming, Christopher Fleming, and Allstate Fire Casualty Insurance and their heirs, agents, successors, and representatives from any and all claims, demands, actions, and causes of actions arising from any action, inaction, or consequence foreseen and unforeseen related to this accident, which occurred on or about the 3rd day of June, 2024. What is your response to the fact that the personal representative signed away all claims?
Well, Judge, you know, they had an opportunity to go through the probate, which never happened.
This is the probate.
Right, I mean, Judge, and so I would say that the heirs can pursue a restitution through the criminal court if they have failed to get restitution through the civil.
You just skipped over my question and you didn't answer it at all, Ms. Woods. His argument is legal. You're making an equitable argument against a legal argument. What is your argument against his argument that they signed this away? And I'm reading a document which says that they did. The personal representative represents everybody in the estate. That's why you have one person assigned.
Yeah, I would just argue that they weren't a party to.
They are a party, though. They're the heirs. So that argument fails. But this is a question that I have, Mr. Green.
Yes.
As I look at this order regarding the distribution of wrongful proceeds, it says right here, it is hereby ordered that no wrongful death proceeds shall be payable to funeral, burial, or medical expenses.
Yes.
What about that? I mean, if they're saying that they didn't get their medical and their funeral expenses paid, this particular order says right here that the funds that they received don't go towards that.
No, Your Honor, that suggests to me that they aren't payable to those particular persons. But the release was that the personal representative is supposed to pay all of those expenses.
No,
That's
it
why,
says right there that these wrongful death proceeds are not payable for that. That's what it says.
well, not payable for, but payable to. They're not payable to. In other words, the individual claimants can't come and say, I want some money from those proceeds.
That's not
But-
a two as in TOO. That's a two as in TO, which means payable to that particular thing, not also. That's not an also.
No, yes, right. That's not my argument. What I'm arguing is that it appears to me that the court is saying that any expenses, any funeral, any burial, or any medical expenses are the responsibility of the estate. And they are responsible for paying any claims.
I don't see where that says that. I don't see where that says that. Has the probate case, has the probate matter been closed?
Yes, Your Honor.
Well, I don't see in this particular case where it specifically excludes the funds that were received as a matter of the wrongful death from paying these expenses. So
It
how
appears,
are you supposed to have those paid?
yes, Your Honor, it appears to me that the court relied on the release, which covers the expenses that you've just described. Medical costs, all of those costs are the responsibility and are included in the release of all claims. The court relied on this release in granting this settlement.
It's an interesting question I think we have here. Because I think that if you look at the face of the wrongful death proceeds settlement itself, there is a provision that says that everything is released and forever discharged. But the court's order specifically says that none of those particular expenses of the estate were to be paid. So I don't understand how they are supposed to be paid if they're not to be paid by the wrongful death proceeds. So it seems to me it leaves open the concept that restitution for those are still something that they could proceed with somewhere else. But Ms. Woods, so let me ask this question. If I rule that they are entitled to the burial expenses they were out of pocket for this particular situation, is there a dispute over the amount, or is there only a dispute as to whether or not they are allowed to receive them at all?
Judge, the only argument that I've heard from defense counsel is that they were not allowed to receive them at all. I have sent over documentation of everything that was paid, and I also sent over bank statements outlining the proof that these were paid by Paris and Medina. And so I don't think there's any argument as to the amount. It's just the argument as to whether they're able to, whether the restitution can be ordered for that amount, if that makes any sense.
Is that correct, Mr. Green? Are you arguing over the amount of the restitution, or just that they're entitled to it?
We're arguing over both the amount and the fact that they're entitled to it. May I bring to the court's attention, there was a hearing before Judge Erane Washington. Both of the claimants had an opportunity to present a claim for anything they may have spent out of pocket. They failed to do so. They did not file a claim at all with the probate court. Nor did they appear in court before Judge O'Brien and assert their claim. And the court says specifically, it makes a judicial finding. It is further ordered that all other wrongful death claimants were served notice of the hearing.
But they're not claimants. They're heirs, first of all. They're not claimants. They don't have to file a separate claim for that. What I
Well-
want to know, well, let me finish talking,
Yes.
please. What I want to know is where is the, there should be a document that distributes the assets. Where's that document?
That's this order right here.
No, that's not. There is a form that is filled out and is provided to all of the actual heirs that explains the distribution process. Where's that document? I need that document before I can make a determination as to whether or not this matter properly includes what they're requesting, whether the probate court properly included that. There's a form that is filled out. And the reason I know is because I did estate work for a little bit when I was in private practice.
Right.
So,
I understand, Your Honor.
where's that form?
Well, the only thing that I can suggest is the inventory, but typically the
Oh,
inventory
that's the
is
first
not the
document.
schedule of distribution. I think the court is referring to the schedule of distribution.
Correct. The schedule of distribution. Where's
But in
that?
this case, the court has made an order regarding distribution. This is the court's order right here.
But
Of
Judge,
who
it
got-
seems that it has to do with, the distribution doesn't have to do with funeral or medical expenses. It has to do with the, the loss of society and companionship through that. And, yeah, it's loss of society and companionship or loss of financial support. It doesn't have anything to do with funeral, burial, or medical expenses with this order.
Your Honor, this is the final order of the court. It makes a ruling that $750 were given to the guardian ad litem. $10,000 were given to Zimbabwe Williams. $5,000 was given to Zimbabwe Williams for the benefit of Noah Williams. And an additional $5,000 was given to and distributed to Zimbabwe for the benefit of Enki and useful for the funding of a 529 plan. It is further ordered that remaining wrongful death proceeds should be allocated and distributed to Shonda Williams, who is the personal representative. That's the full and complete distribution, which means that any debts, any bills, any expenses are to be taken care of by the personal representative. This is the final order of the court.
Well, Judge, it's all of those things that were ordered were for the loss of society and companionship and the loss of financial support. And it also says that it's hereby ordered that no wrongful death proceeds shall be payable to funeral, burial, or medical expenses of the estate of Maurice Williams.
It
So it
doesn't say
appears
that.
to me that this document has to do with people that are claiming loss of society and companionship, not people that are claiming funeral expenses.
That is not the order of this court. This is the final order regarding distribution.
Well, you're using the word final, first of all. I don't see final before this order.
I understand.
And then, secondly, I'm looking for the, to see if there's a different document. We'll look it up and see what I can find with respect to that, because I am very concerned that there's nothing that attributes or takes care of any of the burial expenses.
I understand the court's concern.
Sure. Sure.
All right, so on March 4th, the evidentiary hearing was held. And then on March 6th, the order regarding the distribution was entered. An objection was filed to that. And then on April 17th, it looks like no inventory was ever filed in this case. And then the court entered a order denying a motion for reconsideration. And the case was administratively closed. So I'd like to see what the objections are. And that would tell me what Judge Outside intended by her orders in this particular case. Because she essentially denied whatever the objections were. So I'm gonna need to see those before I can make my determination. It sounds like I'm not gonna make any determination on what it sounds like. But at this point in time, I need to see that before I make my ruling. I don't know what no one else showed up for the evidentiary hearing on March 4th. I can't speak to that, but I can speak to the fact that there's order and been having some interpretation concerns. I think that that the objections may clarify those concerns, so I'll know exactly what the court's intent was in their order.
Is the court looking for a transcript? Is that helpful?
The objections that were filed in that case. I don't believe there was a transcript because it never went to hearing. I just want to see the objections, and the court already denied those objections, so that may address what we're trying to address right here.
I understand. But I don't mind an adjournment for 2 weeks so we can get that. I think it's very easy to get.
I know that the family has been here for quite a long time today, and I certainly hate having them come back. If we like, we can take the testimony today regarding any issues that you have regarding the actual amount so that they don't have to show up next time. That is completely up to you, Ms. Woods, in terms of what you want to do.
Judge, I'm asking them right now.
Okay. Are you able to, you aren't able to get that objections? You're not able to get a copy of it right now?
No, unfortunately not.
Okay,
I don't have to sign.
all right. And I think the problem is that Mr. Green, do you have a sign in for those objections? Are you able to get them today? Can you download it and print it and send it to me?
I can certainly try.
Okay, so the court doesn't have the ability to download the documents. I can only see the register of action. I can't see
Sure.
the actual objections are.
Sure.
Okay. All right, I'll pass this while you continue to talk to your family, to the family in this particular case.
Thank you, Judge.
Thank you. No. No. I'm gonna call the next case. Do we have anybody else here? No.
I believe we have another restitution matter as well, Judge.
Don't put them in jail and
They're in the jail. They haven't been brought yet, Ms. Woods. We will call it as soon as they're brought from the jail.
My apologies. I did get an answer back whenever you're ready, Judge.
All right, what does the family want to do?
Judge, they would rather testify now as to what expenses they were spent.
Okay, thank you. I will see if we can get a copy of the order and then I'll take the testimony. All right.
Thank you, Judge.
The court will call the matters of Thomas Vasher, 25S 4483132, 25FB 1018, and 21S00354.
Works for people.
Ashley Moten on behalf of Mr. Vasher. State your name, sir.
Thomas Vasher.
Thank you. We're here for a pretrial, a sentence, and a payment plan review.
Yes, okay. The payment plan, he has a $55 a month payment plan, I believe. And his wallet got stolen, and then he got arrested on this new case since the last time, or actually technically these are older cases, but they were just charged. But he does plan to make payments when he is released. Regarding the pretrial, he let me know that he does have a valid driver's license.
I did everything you asked. Yes, ma'am. And I got a job.
And you cut your tether off.
Huh?
And you cut your tether off.
The day that it was BS, miss. I promise you, they had me on some BS. They literally put up next to me and flicked me as I'm going back to my house, and then started harassing me on some bull crap. But I did everything I was supposed to do. I've done everything you've asked, everything, and I got a job, and I'm working. I'm doing everything. Man, why can't I? Right.
It's September 29th. Today is September 29th, and his license shows as expired.
No, I went and got my license on the 20-something of last month or the month before in Ann Arbor, Michigan. Ann Arbor, Michigan at Secretary of State. I went and took my test and got my license in.
That's third. Everybody.
I promise to God I did.
The Secretary of State disagrees with you.
And $27 I had to pay. I stood there and took the test. It was 45 minutes. I got 38 out of 40 questions. How would I know they even have 40 questions on the list? I promise you I did it. I got my paperwork at house. Swear to God I got it. I put that on my father's soul. I went and got it. I promise you, you call Marsha right now.
Okay, Mr. Vasher. Okay, 1 second, sir.
I promise you, I did.
Okay.
I did go get it.
So, regarding those two, I would be asking for an adjournment so he can get on track with the payment plan and also figure out what is the issue with his license. It's his understanding that it is now valid. Your records show that it's not. So he will need to call Secretary of State. Mr. Vasher, 1 second, please.
I had to, whatever that is, it was expired, but it was expired. That was it. But I didn't have it. Last time I was with you, I didn't have it at all. I had to go get it, and then it was expired when I got it. That was what they just said. That was it. But I didn't have it at all on the one time when I come and seen you, and you told me I had to go get it. I had to go take my test. I did my test, and they said that it's expired. That's the only thing wrong with it. So now I had to go meet with the people who stood me up the 7 times when I was supposed to get it during COVID. They kept telling me, oh, COVID, due to COVID, we can't meet with you and do the driver's test. So I went to court on that, and Pope had ordered it to where that my license was given to me. But that's old. But it's expired. That's it. I haven't went and got a new picture. I went up there and did the little driver test and did all the things I was supposed to do. I promise you I did that.
Mr. Vasher, do you have anything else you want to say? Because after I ask you this, I'm going to mute you. Anything else, sir?
Oh, I'm sorry. I apologize. Yes, the charges that I'm in here on now are old before you released me onto a tether. And the Miss Garwood stated that she put on there that would revert to a personal bond if I was reinstated back onto my tether and going back out. She put the $100 would be reverted, and the $5,000 will be reverted to a 10%. So that's all. I was just letting you know that, for the first time, I've actually been doing a halfway human things and doing halfway responsible things. I've been
more responsible for this last year than I've been in my entire life. And I'm begging to please try to work with me and give me a chance. And I know I'm not like 100%, but I'm doing way good for me. I'm doing like 160% better. And I mean, like, that's really real. And I'm not out just being a trash heap like I always have been. I'm really doing halfway decent. I'm not that bad of a person, man. I'm not. And I'm doing all I can to try to to do what I'm supposed to do. I'm not doing bad. I'm going back and forth to work for Home and New Vision and speaking for them. I'm doing halfway decent.
Right. Thank you, sir. All right. Ms. Moulton, is there anything else you would like to say on behalf of your client today? He, I guess I should say that he needs to be arraigned on the fact that he cut his tether off. This report is dated September 25th.
I did not know there was a violation for that, so we did not discuss that in the breakout room. I'm just learning this when you said it.
On September 25th at 2:35 p.m., JSG received a strap tamper and a backplate tamper alert from Mr. Vasher. They attempted to contact him and were unsuccessful. At 2:39 p.m., JSG contacted Washington County Metro Dispatch and advised of the violation and requested Mr. Vasher be picked up. They were sent to his home at his last location on Clark Road. And they sent sirens and advised at 3:11 p.m. that he had been detained with his tether cut off, and he was claiming he was having chest pains at the time. They dropped the device. They said they were going to drop the device off. Then they called back. Deputy Phillips said that Mr. Vasher was taken into custody after a short run on a bicycle from the police, and that he was in the hospital, and they were unsure if they'd be able to sit with him due to low staffing at the time. So that is where we are. He has a right to have a hearing on that, at which time, if he's found in violation, then his bond will be revoked. I'm gonna schedule this for a bond hearing. You say, no, October 16th, 2025 at 10 a.m. We'll see him back here on all those matters at that time. You can go in and talk to him now if you like.
Okay, thank you.
You're welcome. Is Mr. Green back?
Yes, Your Honor.
Did you have any success with getting that documentation, Mr. Green?
Not as yet, Your Honor.
All right, thank you. I'm going to recall the case. We can take our testimony. Court will call the case of the State of Michigan versus Christopher Fleming, 25S00001.
Tiffany works for the people.
I'm Roger Green for the defendant.
Mr. Fleming is present. He's in custody. And Mr. Green, before we take testimony, I think we should narrow this down. What are your issues with the actual documents in terms of the amount they're requesting?
I have not received the documents at all. I made a request for them some time ago and still have not received the discovery.
Mr. Green, I sent you the restitution documents. I don't even know how many months ago. And then I also sent you another document this morning.
Well,
I mean, why would I wait all this time to send you, I can tell you, I sent you those documents back on August 19th. If you open, there's a zip attachment to your email that you open it up and it has all of the restitution documents on there. Then I sent you another document this morning, an updated document.
I'll stipulate to the amounts, Your Honor, but my argument still stands that as heirs, they are not entitled to recovery because of the legal release that was signed by the personal representative.
So that the record is clear, I just heard you say you will stipulate to those amounts, but your argument will be as to whether or not they have any entitlement to them. Is that
That's correct.
So we will not need to have him come back to make any arguments in the future, and the only thing we will be addressing is whether or not the law bars them from making this request.
That's correct.
All right. Are we in agreement, Madam Prosecutor, that the only argument is to whether the law bars them from making this request based on the release that was signed by the personal representative? Is that where we are now?
Yes, Judge.
All right. The attorney should submit any additional documentation to this court at least 1 week prior to the next hearing date. I'll schedule this hearing date on October 27th at 11 o'clock a.m. So all documentation should be submitted at least a week beforehand. It is not fair to the court or any opposing counsel to try to have to read documents while they're on the record in the middle of a host of other cases. We need to have adequate opportunity to be prepared for these legal arguments.
I understand, Your Honor. Your Honor, I'm unavailable on the 27th. Is there another day available?
November 3rd at 11, does that work?
Yes, that's fine.
Judge, I would not prefer to do it.
Oh, yes, you're not here. You're
Third, due to our cartel. They're
doing
asking us not to set any,
Yes, I heard you, Ms. Woods. You're doing training on that date. The next date would be November 10th. Are you available that date, Mr. Green?
Yes, I am.
thank you, Judge.
All right, so as the family, you are aware that you don't need to be present here unless you want to be on that particular date of November the 10th at 11 o'clock a.m. If you want to be present, you, of course, are welcome to be present. If you don't want to be, you don't have to show up here. It's completely up to you, okay? And so all documentation regarding this should be to this court no later than November 3rd. And the amount has been stipulated to. The issue is whether or not you're barred from asking for this based on the release that was signed by the personal representative. Are there any questions from anybody?
No, what time is it?
At 11 o'clock a.m.
Thank you very much, Your Honor.
Thank you.
Thank you, Judge.
Bye-bye. Mr. Fleming, you're all set, and somebody's gonna get me a copy of those objections, correct? And the order denying it.
That's fine. I can do that.
Thank you.
Thank you.
Have a good day.
Thank you. Yeah. Everyone's free to leave at this time, and I'll see them back in November. Wait, Ms. Woods,
Judge, there was some confusion as to whether recovery court was on Zoom or in person today. I didn't know. Is it in person?
it's in person like it normally is, isn't it? Yes, it's in person.
Well, we got an email that it was. If it's in person, it's okay. I'm on my way.
Well, you can't be on your way. We're in the middle of the docket still.
Oh, I thought we were, okay. Sorry, Judge.
All right, we're just waiting for the jail to bring Mr. Reese up. Who's the attorney on the Reese matter? Who from the who from the PD's office is handling the Reese?
Your Honor, I am, and I hope we will be able to resolve it pretty quickly. I just need to speak with him very briefly, and I'm hopeful that we can resolve this.
All right, well, he hasn't been brought yet. As soon as they do bring him, we'll put you in a break
Okay.
with him. All right, thank you.
Okay, I appreciate it. Thank you.
The court will be in a brief recess then until Mr. Reese is brought. Well, and he's spoken to his counsel. Miss Allen, you're free to go. Miss Williams, you're free to go as well. All right, the 14B District Court is back in session. The court will call the case of the state of Michigan versus Scott Reese, case number 23-00019.
Tiffany Woods for the people.
Allison Muller here on behalf of Scott Reese. Mr. Reese, can you have them unmute you again and then go ahead and state your name?
While we're waiting, what is the status of this matter, please?
Yes, Your Honor, and I'm sorry for wasting anyone's time or for the late notice. No hearings needed here. Mr. Reese said he always intended to pay for the door, and so we do stipulate to the amount that the prosecutor sent, and we agree to the restitution for the damaged door.
And what is the amount?
Ms. Woods, was it $390.41?
That's correct.
$391.91.
$390.41.
Restitution is ordered in this particular case in the amount of $390.41. And he wanted to have this his probation revoked, so he still has time to serve. Do we have an out date yet for Mr. Reese?
Let me see, Your Honor. I'm seeing if I can find out again. I'm sorry, my ex-jail is.
Mr. Reese, do you know your out date, sir?
I believe it's February 13th.
All right. Let's put this down for a restitution review sometime in May. Can you give me a May 26th date, please?
Do you want mid or beginning or end?
And
We could do, I'm sorry, you said May, not March. The latest Monday date we have in May would be May 18th, 2026, Connor.
May 18th, 2026 at 10 o'clock a.m. Ms. Fetterman, thank you for your time today. I know you've been on here for a very long time or waiting in the room for a long time. Is there anything you wanted to say to me before we have to come back? He's going to pay the $390.41. Do you have any questions, ma'am? No, you shook your head. You don't, anything you want to say? I'm sorry. Anything you want to say? No? I think she's trying to unmute, but I can't tell for sure. Ms. Fetterman, are you trying to unmute, ma'am? No? Okay, you're all set? You can go. Have a good day, ma'am.
Thank you.
You're welcome. Great. I think that's the end of our very long topic, and we're all set.
Okay.
Thank you. Have a good day, everyone. Thank you.
There it is. So that's it for today, everybody. Now, remember, I broadcast every day at 3 o'clock p.m. Central Daylight Time, 4 o'clock Eastern Daylight Time, bringing you different courts, different judges, and different cases. If you guys like the content on this channel and you're not a subscriber to this channel, please consider subscribing to my channel. By subscribing to the channel and hitting all notifications, that lets you know when I go live and any new videos are uploaded. It also helps this platform and this channel grow. So that's it for today, everybody. Ta-ta, ciao. Have a good evening, and I'll see you tomorrow. Bye-bye.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. You make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Make it right. When the world shuts down, and I can't see clear, you're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's okay. Then you